My name is Jordan Henshaw.
And my name is Kelly Raybon.
I'm the mechanic.
And I'm the journalist.
Together
we're Try and Prove It.
Someone has been charged with aggravated murder and is facing the death penalty, so we better figure it out, right?
How do we tell the difference between an assertion that is true and an assertion that is false?
You've got to start with all of the evidence, and you don't have all the evidence just yet.
Okay, well, I have no idea. But it's a dot.
Where's the dot?
Right there.
Science is not absolute. It doesn't say this is what happened for sure. It says this is the best explanation we have.
3, start sequence. 1. If one picture is worth 1,000 words, one field demonstration is worth 100 internet conspiracy theories. I'm gonna ask something at the risk of, being wrong, okay? But we're all just friends here. We're all just talking.
Well, hello. Hopefully you guys can hear me. We are kind of winging it this evening. Jordan, you good over there?
Okay. I just told you.
Now we can go ahead and start, but people don't want to, yeah. Can you hear me?
I can hear you.
Okay, perfect.
You ruined my thing.
Start it now.
You ruined my thing.
We're not going to just, anyway. Okay.
I had a thing ready to go, and then I told you about it twice, and then you ruined it.
Look, you guys, we are limping
do.
along. We're limping along this evening. Please forgive us. Okay, I'm just gonna start off the top because I am on my cell phone, which is clearly causing some issues and some miscommunication here. So we're gonna make the best of it.
It's doing fine. They say I'm lagging, which is odd. Let me turn this off then. Yeah, we had a lot of technical difficulties getting into the show today. They're saying that I have a huge delay, which is odd. I'm turning that off and I'm turning that off. Everyone is saying that I'm lagging, like a lot. That's unfortunate.
Ooh.
1.5 second delay. This INFP ENFP sees you too, and I'm grateful. Yeah, we did the Myers-Briggs a little while ago, but some people are saying it's fine, the lag. I'm gonna have to keep going though because I don't have a control on the lag right now. We did everything we could to resolve the lag issue with Kelly's machine, and I think we're good to go. I'm just gonna. Hopefully the lag will catch up. Hopefully the lag is okay. What I was going to start, let me turn off these comments. I cannot focus. What we were going to start the show off with was basically a moment of silence, of like 60 seconds of silence. And I can't do it anymore because it was supposed to be at the very top of the show. But
you can do it. You can do it now. I thought that it was supposed to be the 60 seconds of the video intro rolling. When you said we were starting it with 60 seconds of silence, that's what I thought the 60 seconds of silence was. I thought the video was rolling quietly because I couldn't hear it anyway. Anyway,
it's okay. We can do it some other time. But the idea was we were going to start the show, like once we go into the live video, we were going to do 60 seconds of just silence. And the reason for that is, what is the purpose of the preliminary hearing? That's what we're talking about tonight. The preliminary hearing starts next Monday, next week, and it's going to go through all next week. What is the purpose of the preliminary hearing? Well, there is a defendant in the case who has been in jail for about 9 months now, almost 10 months. And there's reason to believe that he's been in solitary confinement for an extended period of time. It's really difficult to imagine what that does, what that feels like. But I wanted to kind of sit in that space for a little while of being completely alone for an extended period of time with extremely little stimulation. I wanted to kind of taste that a little bit at the top of the show to set the energy. The purpose of the preliminary hearing is to find out, did the cops make a huge mistake? Was there a massive error that happened that is depriving someone of their life, liberty, and pursuit of happiness? Right now, mostly their liberty. We're putting someone in a cage, a very small cage, for 9 months with very little human contact, very little stimulation. And this can drive people insane. It is a form of torture. Not for a few days, not for a couple weeks, not for a couple months. No, for almost a year now. This defendant has not stood before a judge in any sense of an evidentiary hearing. 100% of the proceedings to this point have been clerical, not evidentiary. We have hardly heard a single scrap of evidence in any of the proceedings to date. So, if the police made a grave mistake, a grave error, this defendant has been deprived of his liberty and has effectively been tortured for 9 months. And my thoughts on that are, when you get locked up for excessive speeding, for DUI, for robbery, for theft, for assault, anything like that, you typically stand before a judge the next day or at least the next business day, and you have a PC hearing. You might stay in jail the night, maybe a couple nights if you're unlucky, it's a Friday night, whatever. But you're going to stand before a judge and you're going to have an evidentiary PC hearing. And I use the word evidentiary as a light adjective, not as a formal adjective. But a PC hearing, a probable cause hearing, to determine, is this tyrannical police law enforcement, or is there a valid legal basis for depriving you of your liberty? 2 days, 1 day, if you're super lucky, maybe the same day, probably not. That's what you expect to happen as a citizen of this country. If you get locked up, you should be able to stand before a judge pretty soon. That just seems like common sense. But if you are locked up for a serious charge, for a capital offense, you don't get to stand before a judge. Not for 9 months. No evidentiary hearing whatsoever. So if someone framed you, that gives the person who framed you a lot of power. No evidentiary hearing for 9 months. 9 months of effectively torture, most likely. Kelly, what are your thoughts on that?
It is something to really sit with for a bit, you know, especially given the fact that, we believe that he's not guilty. I've seen some of the folks in the comments saying, well, it makes it a little easier when, you're getting paid handsomely, or there is a reward that you can maybe look to at some point. But still, sitting in quiet is hard. Even when when our intro was playing and on my end, I couldn't hear the audio, sitting there for 60 seconds quietly had me feeling antsy. Sitting there for 120 seconds quietly had me feeling antsy. So, yeah, I mean, there have been countless studies of the major repercussions and impacts of being in solitary confinement mentally, physically, the overall outcomes for people who, once they do get out of jail or prison, to then either reoffend or take their lives or something like that. Like, it is dramatic. So it's obviously something to take seriously.
So what we're gonna do with this show, it's not terribly organized, but I do have several clips that I'd like to share with you of what are called PC hearings, probable cause hearings. Those are the ones that happen for smaller crimes where you stand before a judge within a couple of days. These are comparable to, but are not equivalent to, the preliminary hearing that Tyler Robinson will receive soon. The purpose of both is to find whether or not there's enough probable cause, or whether or not there is probable cause to move forward with the case. So they have the same purpose, but the scope and the scale are very different. But I am going to play several clips of a judge. Actually, it's actually Kelly's judge, just by chance. Harris County, Houston, Texas is where this judge is located. So if Kelly were to commit a crime, she's going to possibly be standing before this judge that we're going to see tonight. So we're going to see some clips from that to sort of show you what, if you're not familiar with the legal system, we're going to show you what PC is and what PC is not. So this case, the defendant comes before the judge, and the prosecutor reads out the offense report, and the judge listens to it and is like, what did he do? He didn't do anything. Let him go. And then there's other ones where the person actually did do something, and it takes a little while to figure out whether or not there was or was not PC, and there is PC, and they move forward with the case. So I want you to really see the difference between there being PC and there not being PC. That's one of the things we're going to do tonight. And then Kelly also has some information to share on sort of the speed within the context of Utah of this preliminary hearing and how it stacks up against the others. And then after that, we're going to go through the probable cause affidavit for Tyler Robinson and kind of talk about and discuss each point, each element presented in this document, and whether or not we think it does or does not establish PC, probable cause. And then we'll probably go into just general open discussion and audience questions after that. All right. And let me check the chat and see if we're still doing okay on technicals. I think we're good.
In
Yeah,
case
Kelly
you were
would never commit a
wondering.
crime.
That's right.
Okay, we're going to show some stuff from Judge Fleischer now. Kelly, I shared with you this video in advance. And can you tell us what happens in this video? If you remember.
It's been a minute, but it is very interesting, to see Judge Fleischer, which we have earlier this year, just a couple of months ago, we had a whole different issue with a judge in Houston and Harris County that made national news, especially after getting spread on X. But in this case, this is a judge with quite not only a bow tie game, as I see right there in in the beginning of the video, but he's spicy too. He keeps everybody on their toes. So really, I don't think he just assumes that the person standing in front of them is guilty. It seems like he's really tries to elicit a lot more from all parties in the situation to really get to the bottom of things and prove, or determine the validity of the charge.
And this is the kind of judge we hope that Judge Graff, I think his name is. This is the kind of judge we hope Judge Graff is. What happens in this video is there's a claim made by law enforcement that as they tried to get this guy in the police car, he behaved in a certain manner that they felt was obstructing their activities against him. And they write up an offense report saying that he did this, he did that, and they give it to the judge, they give it to the DA, the lady on the left here, who you can kind of see. And she reads it, and then because, reliable hearsay, when they read the police report, the offense report, anything in there is admissible for the purposes of this hearing. So if the cop says this is what happened, that's what happened, right? If the cop says that he went plank, as you'll hear, when they tried to get him into the police vehicle, that's what happened. And the hearing is about to go against the defendant. They're about to lock him up and say that there is PC. However, he has a really good attorney. And the attorney argues that that's actually not what happened, and that the specific charge that the DA chose to file does not apply to this case. Other charges might apply, but not the one that they decided to file. So he gets into the specifics. So as we're going to do later on tonight, we're going to look into the specifics of what exact charges did they file against Tyler Robinson. Are those the right ones? Look at the details. Which ones require mens rea? Which ones require actus rea? Well, they all require actus rea, but which ones require mens rea? I think when we get into the with the minor present stuff, we're going to probably look into whether or not intent and knowledge was there. But anyway, what we're going to see here is a change because the defense attorney looks into the details and there's a video of what actually happened that kind of supersedes the reliable hearsay. So I think this will be interesting. We're not going to play the whole thing. I'm going to kind of skip through it a little bit to give you the general idea. But this is an example of how maybe Tyler Robinson's hearing goes. Probably not, but maybe. This is just to show you how PC hearings can go when they go in favor of the defense.
Yeah, of course. So you were on felony probation for a very serious case. I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon. 4, 5, 6, another unlawful weapon probation for that. We literally had one.
So there he's saying that this guy has an extensive criminal history, and that's the context of the
I just
judge
wanted to
coming
give
in.
you a heads up of, sure,
But be that as it may,
I'm not going to hold, I've never,
Disturbance in progress. It should be located at 4955 State Highway 6 regarding disturbance in progress. Officers received.
So the lady on the left here, she's she represents the DA. She represents the state.
4
or the
calls, all from
prosecutor.
witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
observed what?
located. They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3 points and not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation.
Okay, so the police officer filed in his offense report a certain story as to what the defendant did. And he writes down specific facts that he believes happened, or at least he asserts happened. But we're going to find out whether or not those facts were correct.
All witnesses on scene heard.
And this is important because when we go into the preliminary hearing and we listen to, the document that they published, that like the PC affidavit, the what's the other one, the charging document. They will read that in court and will be taken as fact, just like it is here.
CW and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County.
okay.
Well, they're putting him in a car and he's like going blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe,
So,
but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're
I understand
a 0.1 mile away from the location.
So-
For what?
Well, okay, I get that, but so we have what we have. We've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have,
Okay.
right, Mr. Zenon? there's always two sides to the story. I get it. This is just probable cause.
You're going to hear that phrase a lot. This is just probable cause. That doesn't mean that facts don't matter, but that does mean that the evidentiary bar leans heavily towards the prosecution. So you're going to hear that a lot during the preliminary hearing next week. And for anyone just joining us, this is Judge Fleischer in Texas. This is a different state from Tyler Robinson. So there are small specifics here and there that will be different from between this and Tyler Robinson. Also, this is a very small PC hearing that is significantly smaller in scope to a full-blown preliminary hearing. So keep that in mind as we continue to watch. The purpose of showing this is to kind of elucidate what probable
It doesn't
cause
mean that
is.
you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else that was there another warrant that you said?
It's the.
They end up like this. For them being, at that point, he basically just goes plank like this.
So this is the power of these police reports. When the judge hears this in the police report, it's reliable hearsay. Even if a police officer hears someone saying something, it's called a reliable hearsay. It's admissible in a preliminary hearing. This is standard. It's not a surprise. I know we had all the hearings about it, but the reason that it's admitted is because it's just a PC hearing. So this is the power that the offense report has, that the PC affidavit has. When the judge hears it, he's going to believe it unless there's significant
For them
evidence to the
being
contrary.
unable to effectuate an arrest.
And Judge,
You don't think that's an interference?
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because
And then they go read the code, but then they go into recess, and then they basically said they're going to watch the video later. And we're going to try to
Theoretically,
find
D.
where they come back. Because there is a video. There's police body cam. We haven't seen any body cam of anything that happened on Tyler Robinson, right, Kelly? Talking while muted. Hello.
How about now? How about now? Can you hear me? Okay. I think this will be our first chance to see any evidence besides what was initially put forth prior to Tyler's arrest. And so in case you're just now coming in, I am going to be attending court next week. And we'll come back to some of those logistics in just a little bit because it's continuing to evolve, as you might imagine. But this is really going to be a chance for the prosecution to put on its case, not for the defense to bring forth any evidence. All they can do is speak to what the prosecution is bringing forward.
And here we are going to find where, in this case, they actually are able to bring forward the police body cam, fortunately enough.
interfering with, I mean, we don't know.
let me,
I'm trying to find the start of the next here.
Well,
information.
it doesn't matter, probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Okay, all right, Mrs. Zenon. Sure. I'll do whatever you want to do. You want to set
I mean-
tomorrow? It's around how it brings the worst out in you. You're so wrapped, no, you don't cut it out.
For Ben Judge and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set
I mean-
tomorrow, Monday?
But I would like for you to watch like the 2 minutes of the video that I think.
So Judge, I also, because you had this question yesterday, I called Fort Bend and they confirmed it. The Fort Bend County aggravated assault with a deadly weapon, Penn State was in one.
Of 24.
Yes.
So it was allegedly committed prior to, now nevertheless, it's still a warrant,
It was,
but how on earth has it never been?
it's because other person that he's.
Let them go to TDC. They're after parole. Those are
At the end of the day, even if that happened,
Okay.
Sorry, guys, they're talking about some other unrelated stuff that I'm trying to skip through.
That it's, or vague, that it's unconstitutionally vague. We found case law saying that it's not unconstitutionally vague. It's.
What they're talking about there is the state statute that says, I forget what state statute it was they were talking about, but it was like super, super vague. It could be interpreted any
From
way that the
Contal versus
officer wants.
state.
And then she pulls up case law saying that it's not constitutionally vague. Of course it's not, but it's still
pondered it
constitutionally vague.
you know,
public duties? No. I mean, because it's on video, it didn't happen, Judge. Like, so they get calls for an assault, a disturbance, whatever.
you're telling me the fact that they're saying he goes plank in the car while
He doesn't.
being arrested
He
doesn't
does
happen?
not go plank. It's on video, Judge.
Would they say he uses his, I guess he uses
He's in
his,
handcuffs.
The officer has to place his hand on the chest of the defendant to get the defendant to sit back in the car. He also has to grab his legs and push them back into the car. We also watched the video.
We watched the video and we have a timestamp, Judge.
could it be that okay, so I know that a lot of times. Yeah, right there.
And here's where they play the
You
video.
said it.
I'm just turning the volume up, Judge, as well.
He talking about don't let them pull up. They talking about I got a warrant out for Fort Bend County for assault. Look, he pushing me. Mama, record me.
It's really hard to see, but then
Come on.
Thank you, Judge.
Really? That's it?
That's it, Your Honor.
That's the relevant portion that defense is.
Oh, come on.
The officer is investigating legit.
so what happens is, and we'll get into some more excitement here, we'll get into some more excitement here, but basically what happens at the end of that is they watch the video and it's like, no, that's not what happened. Obviously, no, there's no exit wound. There should be an exit wound. What are we talking about here? And then he just lets him go. That's basically what happened in that video. Not really, but that's basically, like, when you watch the video, that always speaks louder than the documents. Like I said in my Whoops in Finance did a reaction video to us when we had James May on earlier, and we did our mock trial. He didn't like my opening statement. I wish he did, though. I think my opening statement in that mock trial was great. And the purpose, he liked the rest of it. It was a great, he really liked the rest of our stream. And we appreciate him for doing that video. But the purpose of my opening statement was, hey, these documents, like in this PC hearing, the documents can say whatever they want, but the documents don't control the truth. You can either look at what the documents say and what the police want you to say and the narrative, or you can simply look at the truth for what it simply is. And what we think the truth simply is in this case is, the shirt yanks up to his ear, and that's just not consistent with anything that would happen because of a 30-06. And I was hoping, I think Kelly's typing, okay. So when we look at, you're talking while muted again.
There's a significant delay, so I apologize for that. Yeah, it's just like seeing your mouth move and then hearing you. It's two totally different. I don't know if it's like that for those who are watching.
You know what? Let me rejoin. Why don't you go ahead and take it? I'm going to rejoin and see if that helps. Okay.
Okay, that sounds good. Okay, well, Sorry again, you guys. We are dealing with some technical issues because my laptop got put in the Apple hospital unexpectedly this evening. I was told it was going to be a 20-minute fix, and it was not. They said 3 to 5 days. And that's a problem because I'm going to be going to Utah and I need my laptop. Welcome back, Jordan. Hi, Jordan. Oh my goodness.
No,
Hi. In the world are you doing?
I'm
I don't-
supposed to be able to put you on the left, but it won't let me put you on the left. Doesn't
Okay.
matter. Sorry. Please proceed. My apologies.
Oh, that's okay. I was just saying that we were dealing with some extra special technical difficulties this evening, so we appreciated everyone's patience.
Yes.
But yeah,
And this is partially FedEx's fault, too. It's not just Apple's fault. It's also FedEx's fault. Because you're supposed to have a much nicer computer now, but it didn't arrive today, unfortunately.
that's
But
okay.
all the problems
Anyway,
will be solved very
we'll
soon.
keep it. We'll keep it moving. We'll keep it moving.
Is my sync better now?
No, it's okay. Don't worry about it.
Well, we tried the best we could.
That's right.
We can fix it in post.
Yep. Okay,
So,
so
what we were
I am
talking
curious.
about-
I'm going to ask real quick. Kathy, who is in the chat, just mentioning that there was a lady that worked at a dealership. This is regarding the alleged vehicle, from September 10th that was sold off. So you're saying that supposedly the person said that she could find it or that she couldn't find it? There's a lady that works at the dealership that was trying to tell them she could find it. Anyway, interesting. Okay, I'll keep talking. Yeah, I missed that stream earlier today. I was dealing with all this unexpected computer drama and was not exactly how I planned to spend the day. And worst case, I'm going to have to go buy a new laptop and take it with me to Utah. So not looking forward to that. But they said, I could always return it, but that's a lot of work. Jordan, you okay over there? Yeah, if absolutely. Hey, if someone finds it, in theory, you could buy it, I guess. I would definitely suggest going and, I don't know. I'm not sure exactly how you would sample for what you would use to swipe anything in there, but that would be interesting. There's got to be a test kit for that. I don't hear you at all,
If
Jordan.
someone finds what?
Oh, now I hear you.
If someone finds what?
Oh, the vehicle in California from September 10th.
What
The
vehicle?
rental, the Denali.
Oh, it's in California now.
Yeah. We've known that for a couple of days.
Oh, okay.
That it was, yeah. At least it feels like, yeah, I think it's been 2 days. Yeah, it's lots of things. We could have known it a long time ago had those with the photos shared the license plate, and they've had that for a long time. So that's a little disappointing. We could have tracked it long ago.
So my AV sync is still completely messed up.
It is.
Why don't I just reboot my machine? Kelly, would you possibly be able to go into the stuff that you had prepared?
Sure. I could do that. Give me just a moment here. Well, you guys, we're really roughing it today, but we appreciate you being here. So some of the things that I was looking into at least a couple of weeks ago that I hadn't had a chance to talk about yet on Try and Prove It is the idea that a lot of people feel it's taken so long for Tyler to be able to have his preliminary hearing. And while I agree, it does feel like it's a long time. I'm going to help put it into perspective. How about that? So I'm going to read a few things out to you, but it turns out that Tyler's actually a little bit, a good amount ahead of schedule when it comes to preliminary hearings for complex felony cases in Utah. So the Utah Rule of Criminal Procedure 7 does require a preliminary hearing within 14 days for in custody defendants and 28 days for out of custody. Extendable only for good cause shown. In high profile felony prosecutions, that window stretches by months, sometimes even years. So I looked at several different cases, everything from Corey Richens, which a lot of people are familiar with that case because Kathy Nestor, who is the lead defense attorney for Tyler Robinson, also represented Corey Richens, and that case just wrapped. Corey was found guilty recently. How you doing over there, Jordan?
Is it better?
I think so.
Perfect. Okay.
Yes. Oh my gosh, so much better.
Okay. How much of the prelim hearing from Corey Richens did you listen to?
I listened to a couple of days worth, but I listened to more.
How many hours?
I listened. I don't know, a few.
Oh, perfect. Okay.
No, I'm frozen. Okay.
Was it like torture?
I mean, no, it wasn't torture.
Felt like it to me. I listened to the entire first day and I walked 10 miles at the park while listening to that. It was terrible. Like the whole first day, the whole 5 hours of it. It was terrible.
Look, I have, I don't know, a different barometer than you, I guess.
But the audio was kind of bad, so that made it a little bit more difficult to hear.
Yeah.
But
that's true.
Okay. So what happened in that preliminary? Like I wasn't here, so I don't know exactly what Kelly already said. But the reason we listened to that and looked into that hearing is to find out, like, we're not lawyers. We're not standing in court every single day. It's not like an everyday kind of thing for us. So we don't necessarily know exactly what a prelim hearing is. Maybe Kelly does. I don't know. But I didn't. What is a preliminary hearing? We don't know. We want to find out. We want to kind of like go forward in time in a time machine to see what it actually looks like. The first thing that I noticed was, number one, it's not narrative based. They don't stand before the judge and say, this is what happened, then that happened, then that happened, then that happened, the way you would for a jury. And that's because the judge, there's no jury in a prelim hearing. The jury is the fact finder is the judge. And the judge is already super, super deep into the case. He already knows all of the evidence that's come in, all of the arguments, or not all the arguments, but all of the stuff that's going to come in. He knows more about the case than we do, probably, at least the one that's in writing. So they don't have to start with, this is who the defendant is, this is who Charlie Kirk is, this is what happened. They don't have to go into any of that stuff. So it's not like when you see mock trials like we do on the show sometime, where we do this long drawn out narrative kind of theatrical thing where we make a case and say, this is what happened. No, they're not going to do that. They're going to jump right into super boring cross examinations, right?
Yes, that's correct. And I had just pulled up. So with the Corey Richens case, it took actually 474 days from arrest to the time of the preliminary hearing. In the Tyler Robinson case, we're talking 300 days. So it took Corey a substantially longer amount of time, and she was charged with aggravated murder.
I am pulling up this thing that you texted me. Is that for public consumption?
Yeah, yes.
Okay. You don't say please.
Hey, I'm just trying to hear you at this point. It's still glitchy. So I don't know if it's my end or your. Yeah. But just don't worry about it.
Okay, I'm going to share this perplexity conversation, right?
Mm-hmm.
Okay.
So you can click on that case tracker.
The case tracker.
The white part. Yep.
Utah's 14 to 28 day rule meets the reality of complex felony cases. What is the 14 to 28 day rule? Utah Rule of Criminal Procedure 7 requires a prelim hearing within 14 days for in-custody defendants, 28 days for out of custody. Why was this not followed?
Because they waived their right to they waived their right to that initial, so they set it for later.
Why?
Just go, because they don't have all of the evidence and it's a complex case and they have to figure out, they're still gathering.
So he could have had it within 14 to 28 days.
Well, both sides are able to discuss this. But yeah, it makes sense. Like no one, you can tell as you look forward, like it's a standard felony that someone maybe on average there's like 14 days. But like when it came to Ruby Franke, which was another case that a lot of people know, she was once upon a time an influencer, a family influencer in Utah, and ended up being charged with, I don't have her list of charges in front of me, but I think it was like aggravated child abuse. Let's see. Yep, aggravated child abuse. She waived her preliminary hearing and went ahead and put in a plea. And so she ended up testifying against Jody Hildebrand. Mm-hmm. This is why they say each case is different. You guys, like every single time there's different facts that need to happen. But that was a high profile case and it took 110 days to have her initial preliminary hearing. And then, or before she entered a plea. And then for Jody Hildebrand, she took her 119 days. She waived that preliminary hearing. But when it comes to another aggravated murder case, the case of Mackenzie Lueck, I don't know if I'm saying that right, forgive me, but it took 488 days for that preliminary hearing to happen. And then it was waived just before, and I think a plea was entered. 488 days. That's so long.
That's like almost a year and a half. How soon before that prelim hearing was it waived? Do you remember?
Could you say that again?
How soon before the preliminary hearing did Lueck waive it?
Let's see, 3 weeks. 3 weeks
Okay,
before.
so it's okay. So that's like we're not about to hear Tyler Robinson do that, probably.
We'll see.
We'll see. Okay, so like this is great. This is the context of.
Actually, I would say fingers crossed, most likely not, because tomorrow is a holiday for the court. And so at this point, everything is moving forward. Like it would be
Mhm.
stunning. I don't even know if the court would like accept it at this point, unless it happened
Yeah.
like literally right before court begins at 8 a.m. on Monday.
Yeah, there's no time.
And we're
It's gonna happen.
already told to be there way before. So
You have to get up early. Okay, so this is great. This is what our show is about. It's providing context for,
Very.
How unusual is this or is this not? Turns out it's not very unusual. So, is there other interesting stuff in here? I mean, I'm sure it's all interesting, but for the show? Prelim explainer. I don't know if you heard me. Maybe I cut out. Can you still hear me?
now I can.
I was asking if there's other stuff in this perplexity conversation that we should look at.
Let's see. So if you look at these 3 tracked contested capital preliminary hearings between Corey Richens, Tyler Robinson, and Ajayi, who was the defendant in the Lewick case. The average arrest to preliminary timeline was 421 days. That's 30 times the statutory 14-day in custody deadline. But I guess it's because it's complicated. But still, with all of that said, Tyler is getting to have his initial day in court, so to speak, far before those other cases.
Mm-hmm.
In Tyler's case, I mean, the defense had moved the March 30th, 2026 for a 6-month continuance because remember they said it took the prosecution and which includes the FBI, right? Even though the FBI technically isn't processing or prosecuting the case, the FBI still had evidence that it had yet to deliver or allow the defense to see. And there was a voluminous amount of information that suddenly got plopped in front of the defense. And they said, hey, like, we need a lot more time to review all of this so we can be prepared. But they kind of hit that right in the middle. They just moved it to 3 months instead of going the full 6 months.
Why would you waive this though? If you're sitting in prison or in jail and you're basically in solitary confinement, you have a choice. You can either have a prelim hearing. Guys, we got to quit talking about Blake in the comments. I see nothing but comments about Blake. Like, we're not talking about Blake tonight. I don't think he's in here. All right. When you are in solitary confinement, basically in jail, you're given 2 options. You can either have your preliminary hearing, your first chance to get in front of a judge for an evidentiary hearing in 9 months. You can sit in jail for 9 months, or you can sit in jail for 14 days, 28 days, and then have a chance to get out. I don't care. Like, what evidence do they have to sort through that's going to take more than 14 days?
Well, I don't think they turned over anything by 14 days to the defense team. And so at that point, the defense, I mean, they don't have to. But the prosecution is also able to ask for more time. I'm pretty sure that they did that. I mean, I'm operating on my
What is this rule?
on
I
my
want to look up
phone
this
right
law.
now, but
I want to look up this law because
I
it just feels wrong.
okay, well, I think you may be getting
No,
a little caught up in minutia, but we can look it up.
no, because okay, can this be weaponized? If the prosecution just refuses to hand over the evidence in 14 days, is that a weapon they can use?
Of course it is, absolutely. But I mean, there's also a level of reasonable, like everything, I guess, is a chess match when it comes to this stuff, right? And so the defense is trying to be has to be, or you would hope would be reasonable in trying to pick and choose their battles.
If Tyler Robinson is innocent, I want my prelim hearing on day 14. I don't care how much evidence they've handed over. Whatever evidence they're gonna use at the prelim hearing, we need to have that before the prelim hearing so we can figure out what our response to it is. They're not going to present 50 terabytes of evidence at the prelim hearing. Give them 7 days to put together their stuff, and then at that 7 days, give us their stuff so we can form our defense. It shouldn't take 9 months to figure out what to do with that. Like give the prosecution 7 days to get their stuff together, and then give the defense 7 days to get their stuff together once they have all the stuff that the prosecution's actually going to use. And then let's have the prelim hearing on day 14. Why can't we do that?
Well, let's see here. I like that. Also, this is a good point. I mean, jail.
No,
is a
seriously
safe
though,
place
why
for
can't we do
some.
that? Why can't we do that?
Well, I think that everyone has to agree to that, and ultimately the judge order it. I mean, as he ordered it, and as he set the preliminary hearing for this July 6th date. But it's a dance between all the sides.
But the prosecution should not be okay. Here's the law, I believe. Let's look
I'm
at the
researching
law.
it though in the meantime as well.
Perfect. Let's try to find the important part here. Let me just do a search for 14 because this is important. Like this is what we started off here with was the moment of silence that we didn't do, but 14. Like if he's being tortured for 9 months,
Okay,
if
so I'm gonna
he's innocent.
while you're digging into that.
Go ahead.
Oh, okay. Oops. I don't think his middle name is not Oswald, but
I think
some
it's
people
James.
might feel that. It is Tyler James Robinson. But okay. So why an innocent defendant would still wait? Here's the thing that people miss. The 14-day clock is not a stopwatch on the defendant. It's a leash on the state. This is according to my perplexity research. Okay. Utah's rule says that the prosecution cannot drag its feet. They have to be ready to show probable cause within 14 days if the defense demands it. But that clock belongs to the defendant. It's a floor for how fast the state has to move, but not a ceiling on how much time the defense has to prepare. Every experienced defense attorney in the country will tell you the same thing, that rushing to a preliminary hearing when you are not prepared is malpractice.
Why aren't they prepared though?
Especially if your client is innocent. Here's why. Okay. Utah barely has discovery. The preliminary hearing is the discovery. In civil cases, you get depositions, interrogatories, document requests, months of it. In a Utah criminal case, however, almost none of that exists. The preliminary hearing is basically the one early chance that the defense gets to see the state's witnesses under oath and hear how they will ultimately tell the story at trial. If you cut your prep time, then you basically just threw away your only investigative tool. It's the sneak peek, and you only get one. Every defense attorney calls the preliminary hearing the sneak peek. It's your one early look at the state's case. So how solid the witnesses are, where the holes are, what the prosecution actually has versus what maybe they told the press early on.
I'm
They
ready
are
to
allowed
crash
to-
out.
Right? They are allowed to cross-examine the defenses. And so they want to be ready for that opportunity. Then there's the sworn testimony, which equals impeachment ammo for trial. Whatever the state's witnesses say at the prelim, they are saying under oath. If they change their story at the trial, then the defense can pull up the transcript and lock them into it, which is gold. But this is the part. It's only gold if the defense knows the case well enough to catch those inconsistencies in the first place. You can't impeach what you didn't know was a lie. And then there were all of those motions for suppression. Okay. There was a ton of them when it comes to chain of custody, hearsay objections, cameras in the courtroom, whether the roommate's texts come in, whether the roommate shows up at all. You know, all of that has to be argued before the preliminary hearing, or the defense loses those fights forever. We know that Tyler's defense team, Kathy Nestor and company, have already filed a stack of them, and that takes time to work through. When it comes to the speedy trial clock, it is totally different because it does not start at arrests. It starts at the not guilty plea after the bindover. So let's remember that Tyler has not entered a plea yet. I know that seems crazy, but that's just the way that it is. He has not entered his official plea yet.
Who designed this system?
Jordan.
I want to find out who designed this so we can design it better.
The founding fathers, I don't know. Someone who is long gone.
I think we can design a better system.
Are you okay? I'm gonna let you work on that one.
Because this is why, okay, what is the important part here? This system has been designed in such a way that it actually takes 9 months to just have a PC hearing. Why does it take 9 months? It shouldn't take 9 months. I don't care what the excuse is.
Yeah.
You cannot deprive an innocent person of their liberty for 9 months because that's just the way the legal system works. I don't care what the excuse is.
Well, I don't know. I mean, they didn't turn over, and that's what I would say that his defense attorneys were pleading, you know, and being frustrated with the prosecution over because they're like, what's taking so long? The FBI hasn't given us access to Tyler's phone or to the gun. And so, yeah, they made the case for that like March 30th, I believe.
And
And so
But-
basically they said, chop, chop, let's go. But then also it could be that it's safer for him in jail. If he's even really, in jail, we don't know, but.
The prosecution dragging their feet should not have an impact on how long an innocent person could be held hostage.
Mm-hmm.
So why is it designed in such a way that the prosecution dragging their feet is going to extend the prelim hearing by 3 months, 6 months, whatever the case may be? Yeah, give them 33 months. I'm just thinking about the design of the system. The design of the system is wrong. The design of the system should not allow this to happen. I understand that there's a reason that this happens, and I understand there's a reason, but it's not okay. It should be faster.
Mm-hmm.
I'm making an appeal to the way the world should be, not to the way the world is.
There you go.
Here is the law here. It says, I thought I had it here. What happened? I thought I had it right here. Hold on. Is this it? I just had it up here. I must have. Hold on. I'm sorry.
Are you in a different tab or no?
I'm in this tab. Here it
Okay.
is. I found it. Right to preliminary hearing. This is the state statute, I believe. I'm not going to scroll up and lose my spot, but I believe this is the state statute that mandates what we're talking about. Right to preliminary hearing. Point 1, the court will inform the defendant of the right to a preliminary hearing and the times available for holding the hearing. If the defendant waives the right to a preliminary hearing and the prosecuting attorney consents, the court will order the defendant bound over for trial, so he won't get out. Number 2, if the defendant does not waive a preliminary hearing, the court will schedule the prelim hearing upon request. The hearing will be held within a reasonable time, but not later than 14 days after the request. If the defendant is in custody for the offense charged and is not out on bond, and not later than 28 days after the request. If the defendant is not in... Wait, hold up. This is a very long run-on sentence. Okay, read that again. The hearing will be held within the reasonable time, but not later than 14 days after the request, if the defendant is in custody for the offense charged, and not later than 28 days after the request, if the defendant is not in custody. I need to read that over again because I'm still not understanding the flow of that very long run-on sentence, but I'll read the next one. These time periods may be extended by the court for good cause shown. Upon consent of the parties, the court may schedule the case for other proceedings before scheduling the prelim hearing. I need to try to figure out what this sentence is saying. The hearing will be held if the defendant is in custody. If the defendant is not... What? I don't know if you guys can see this. I'm going to zoom this in. I'm just trying to understand what this thing is trying to tell me. But it's very difficult to understand.
Can you drag your cursor over where you're at? Because it's so small for me. I can't see it.
Right here.
Okay.
God, why does it do that? Where did it go? All I did was zoom in. Now I lost my spot again. Hold on. I'm sorry, guys. I just want to understand what this says. Can we fill the space?
Okay, do you want to
with,
search for 14? I think maybe that would help.
No, because it's everywhere, the number 14. And I just had it on the screen and I highlighted it, but I can't find it. Even though I highlighted it. This makes me so sad. And I just want to be able to read the same sentence again that I just read twice.
Thank you, Roger, for gifting 10 Kelly Raybon memberships. I appreciate you so very much. Thank you. Thank you. Grab them if you can.
Why can I not find it? I just had it.
Just try 14 days.
That number is everywhere in this document. I already tried it.
Okay.
Okay, we'll try it. 14.
Days.
33. 14 days. 23 results.
Okay, well, just tab. So in the meantime, I can say, oh goodness. Okay. We're going to, yep, what?
I just had it up. And I just tried to zoom in.
Okay, all right. You focus on doing that, and I'm going to do a little more explaining, okay?
Please do.
All right. So just to kind of recap here, you guys, Monday morning in Provo, a judge is going to sit down and ultimately answer one question only. Not did he do it, not should he live or die, but does the state have enough evidence to make Tyler Robinson stand trial for the murder of Charlie Kirk? That's what this preliminary hearing boils down to. Now, if you've been reading headlines calling this a delay or a stall or a circus, we're going to get into all of that. I think Jordan thinks that it has been. I mean, I think we all think that it has been to an extent, but in my opinion, it's because, this is all a charade anyway. But that's just my opinion. Now, here's where we should clear something up right up top, because most of the confusion of this case comes from people treating a preliminary hearing like it is the trial. So people were so up in arms about, why is Lance Twiggs only showing up on a video statement and not actually being there in person to question. But hearsay is allowed. And because this is a probable cause hearing, then there's we are just at the point of determining if a jury could reasonably convict, not beyond a reasonable doubt. No verdict is going to come out this week. Most the judge is probably not even going to make a ruling on this case based on what we've seen over the last, I don't know, at least half a dozen hearings. He does not make a ruling that day. He takes it into consideration, and then he comes back and either issues a ruling. I mean, this is so significant, he'll probably hold an in-person hearing. You good over there? Or you want me to keep going?
I truly think this sentence is impossible to understand. Can you try to understand this for me?
Oh, God. And I'll just tell y'all that I do know where Lance is, and I'm trying to work on a story on that. I've been working on it for a while, but for those who are with us right now.
It says the hearing will be held within a reasonable time, but not later than 14 days after the request. If the defendant is in custody for the offense charged, and not later than 28 days after the request. If the defendant is not in, what?
Yeah, Jordan, that's not that hard. Okay. So sometimes a defendant is not in custody. You've been charged with the crime, but you have been allowed to, you're not in custody.
Right. But it says,
you've been granted bond.
But in the middle of the sentences, it says if the defendant is in custody, but then at the end it says if the defendant is not in custody. It said, okay, the hearing will be held within a reasonable time if the defendant is in custody.
Right.
I think I
For
understand
the
what it's
offense
saying
charged. Yeah.
now. I think I
And-
understand what it's saying now.
Okay.
I think I understand what this is saying now.
Okay. Thank you, Duck and Felonies. Like we talked about at the beginning, 14 days if in custody, 28 days if bonded out. Are you there?
Yeah.
Okay.
Do we have any other chats? I'm going to fix this sentence.
Oh my gosh. Y'all, this is Jordan. When he gets on something, you just don't even bother trying to reel him back in. Like cast that out there, and it's just, I think my my fishing line broke because Jordan is out in the middle of the pond. So I'm not even going to try to reel him back in. Okay, so I'm going to continue back on the 14-day rule and its very big escape hatch, okay? Here's where it gets interesting. Utah law says that if you are locked up in jail waiting on your prelim, that hearing is supposed to happen within 14 days, as we just heard. Here we go. Now, 14, if you're out on bail, 28. That's the promise that the statute makes, but this same rule has a built-in escape hatch. A judge can push it back for what's called good cause shown. In complex felony cases, that escape hatch gets used a lot. And we're going to talk more about how and why. So Judge Tony Graff will be on the bench, and prosecutors are going to get to put their witnesses on the stand based on the witness list that could still change. I saw it as of last night. I haven't looked today, but it was primarily law enforcement types. I think it was one UVU officer, several Utah Special Bureau of Investigations agents, and then the Lance Twiggs video. Okay. Let's see. The defense will get the opportunity to cross-examine, but they're not putting any of their own witnesses on the stand because, again, that is not how preliminary hearings work there. And then this is scheduled to run for 5 days, and it tells you that the state is planning to put a lot on the record. To me, based on what I've seen listed on those documents that kind of give us a sneak peek, it doesn't look like it's a whole lot more that we haven't been made aware of yet. But I don't know. We'll see. Do you want to chime in, Jordan? Are you chomping at the bit over there?
Let me rephrase. The hearing will be held within a reasonable time. If the defendant is in custody for the offense charged, that time will be not later than 14 days after the request. If the defendant is not in custody, it will be not later than 28 days after the request.
Okay. You feel better now?
I feel much better now.
Okay. Are you gonna go to the Utah legislature maybe soon and see if you can, as a non-Utah resident, try to have the language changed?
I should do that. Yeah, maybe I will.
You should.
Get some laws
You
changed.
should.
Maybe I'll get a one of those trophies.
Hey, you could. You know what? Never say never. I could see it in your future.
I
Okay,
have those
so
videos.
Oh, go ahead. I was going to say we can talk about the delay narrative fact checked. Why September to July isn't exactly what it looks like. Yeah, you want to go there, or is there some kind of video you were wanting to show?
I have more Judge Fleischer videos, but we didn't like the other ones. But these are shorter.
Well,
let's play a couple of those.
Okay.
This is actually interesting. This is fun. This is a YouTube Shorts, so it's it's not long.
Possession of marijuana, you're facing up to 6 months in jail and or a $2,000 fine. Shh. You're going to do probable cause. You have the right to remain silent. Anything you
I
say
don't hear
can
it.
be against you.
Hold on. You don't hear it?
I don't.
Does the chat hear it?
Keep playing it so the chat can
Have an attorney
determine
present,
if they
not
hear it or not.
one will be appointed to you, sir.
We
Yeah.
can read it at least.
On November 22nd, 2024, the officer observed the defendant's vehicle parked more than 18 inches from a curb on a public roadway. in
Yes,
the right lane.
Reginator, clearly,
While the officer ran the
he
motor
is quite the
vehicle,
dresser.
door
He is a
open,
fashionista.
the female approached the patrol vehicle. The officer made contact with the female and observed a strong odor of marijuana emanating from the female.
Yeah, I don't hear anything.
The defendant, the driver of
And
the
then
vehicle,
read
someone
it.
said,
observed a strong odor of marijuana and had the defendant exit the motor vehicle.
oh, now I
Feces
hear it.
the
I
officer
guess
located
on my laptop.
in the driver's side door and one blue package with oops all berry on the front containing green leafy substance. On the rear driver's side floorboard, one red package with fruity pebbles on the front containing a green leafy substance in the back seat, and two clear plastic baggies containing green leafy substance on the front right passenger seat. The officer also parked more than 18 inches from the curb on the right lane of a two-lane two-way road.
How on earth are you going to know that you're parking more than 18 inches? What time of day or night was this?
Your Honor.
Parking while black now?
Your Honor, there's no time listed. It just says the officer was on patrol around the everybody can walk apart or drive when he observed the
It's
vehicle
going
parked more
very
than 18 inches.
fast.
Car because of that?
No, Your Honor, a female passenger side exit the passenger side towards their vehicle and he observed a marijuana.
Because he comes up to that, right? Stop. Are you losing?
The officer, as he ran the vehicle, presumed the license plate.
Yeah, he pulls him over.
You're already parked on the side of the road, 18 inches from the curb, and he, I guess, parked behind, he was running the vehicle, and then the passenger side door opened, a black female exited and approached his vehicle, the patrol vehicle, and he observed a odor of marijuana from the female, and then he made contact with the driver, where he observed marijuana odor in the vehicle. So the female approached the patrol vehicle.
Show me the penal code, that code. What's the penal code?
Regarding 18 inches.
Okay. So in that video, it's fruit of the poisonous tree stuff, right? So there's no lawful reason for the stop, and then everything else is thrown out after that. But that's not particularly relevant to the case. But I just
Mr. Blake,
thought it
you're
was
charged with
interesting.
possession.
Then we can get to another one later. But Kelly, I think you had some more stuff.
I did. Okay, we're going to
Right.
talk about the numbers that everyone is throwing around. The Tyler was arrested in September of 2025. His preliminary hearing starts July 6th, 2026. So that's about 300 days from arrest to hearing. And, we think, oh, well, is he getting special treatment, or is the system stalling? Are the lawyers on vacation? Is the prosecution scared? So here's the thing, when you actually pull the receipts on comparable cases in Utah, especially capital cases, 300 days is not the outlier. It is more in line with the pattern. So Corey Richens, the children's book author, accused of poisoning her husband, Eric, with fentanyl in a Moscow Mule, arrested May of 2023. Her preliminary hearing didn't happen until August of 2024. That was 474 days later. Why? Well, her entire defense team had to withdraw in May of 2024, citing irreconcilable and non-waivable conflicts. That's when Kathy Nestor ended up joining the team. New attorneys, Nestor and Lewis, same firm, now defending Tyler, had to get up to speed on a mountain of discovery, and then on top of suppression motions and expert challenges and Rule 1102, which I'm not sure what that is, fight over what the judge could and couldn't consider. So 474 days. That is a long time.
Oh, that's the hearsay rule. Rule 1102, reliable hearsay. That's what that's about.
Okay. Then another case would be the Ayula Ajayi. Sorry, I need to learn how to say the name. That 488 days. and they were convicted of murdering University of Utah student Mackenzie Lueck in June of 2019. His preliminary hearing was 488 days after his arrest. It was a capital case. There was a massive digital and DNA evidence pile to go through, and the case still moved to conviction. Nobody called his timeline a scandal either. That was just how long the capital prelim actually takes when the evidence file is measured in terabytes. And we know that in this case, they've said, do you recall, Jordan, was it like 30 terabytes, 300 terabytes? I mean, it was something that was outrageous.
It's like 50 terabytes or something. Yeah.
Yeah, something crazy. So here comes a comparison that could be really important for us. When you put it all in court, the statute says 14 days. The average for contested Utah capital preliminary hearings, the actual comparable cases here, comes in at around 421 days. That's a factor of over 30 times what the statutory deadline, theoretical deadline is.
So it doesn't work.
Tyler's on the short. Yeah, it doesn't work. But I mean, but maybe it does. That's that's the point that I was making earlier, is that there are advantages to the defense team by having more time, because this is their big shot before trial.
How often do prelim hearings actually find no PC? Do we know that number?
No, you're posing the question, so.
Find no PC. Okay, this is just the AI overview. I don't know how accurate this is, but it says, let me zoom in. If I can get it to focus over here. Findings of no PC at a hearing are very rare or very rare. Probable cause means there's no, it just says it's very rare. So then I guess the purpose of the PC hearing is not to get him out or them out. It is to just find out what the prosecution has.
Mm-hmm. So, okay, what actually eats at the clock? There are 7 documented reasons that we should consider, okay? And every single one of them is present in Tyler's case. 1, the discovery volume. So Kathy Nestor told the judge back in September that she had massive amounts of digital data to review. So let's consider that's extractions, Discord logs, ballistic files, DNA analysis. I mean, she's going to want to, the defense is going to want to go through all of those things and probably run things by their experts that they rely on as well. So that way they can be as prepared as possible to get to ask solid questions. Number 2, counsel changes and coordination. Tyler's defense had to spin up from a public defender appointment to Nestor Lewis, the same people that inherited the Richens case. And Corey Richens just had her trial back in the spring. So I remember definitely Kathy Nestor saying, hey, I have a big trial that I've got going on. So that set things back too.
Do we want to go into the PC affidavit now?
Can I just try to blaze
Sure,
through
go ahead.
these few other
Go
things
ahead.
real quick?
Go ahead.
Okay.
Yeah.
3, the specialized motions practice. In the last 60 days alone, this case has had motions to close the hearing from the public, motions to ban cameras entirely, motions to suppress hearsay, subpoena fights over Lance Twiggs, and a contempt show cause against the prosecution for that pretrial publicity, the TMZ stuff, and some of those other statements, and then also had to have rulings issued on all of those things. So when you think about all of the stuff that's had to be sorted out, all of that has to be dealt with before you have the preliminary hearing. 4, expert and lab evidence. So DNA on the rifle, ballistic matching on the bullet fragment. Those reports, don't get written in a weekend. It takes apparently an excessive amount of time for all of those things to come through. Do we wish that they came through faster? Absolutely. But, the reality kind of is what it is.
I want to take this back down to ground level.
Okay. Are you there?
Yeah.
Oh, you said you're going to take it back to the ground level?
Yeah.
Okay.
Just has to sit in jail for a month, 2 months, 3 months, another week, another hour, another 10 minutes, another 20 seconds, another month, another 2 months, another 3 months, another week. All this legal stuff going on. And no evidentiary hearing. We can talk about the legal stuff all day long, but this is someone's life we're talking about. I mean, we're talking about 2 people's lives, according to the official story, at least. Charlie Kirk's life, which deserves justice if that's what happened. But also Tyler Robinson's life. Most of the people in the chat, most of the people watching, ourselves included, don't think that Tyler Robinson did this. And maybe he deserves to be where he is, but maybe he doesn't. Most likely doesn't, according to what we've seen. 1 month waiting. Another week waiting. Another 5 minutes waiting. Pacing in his cell. Another 20 minutes pacing in his cell. Another month goes by. Another 2 months. Another 3 months. While we're all talking about this legal stuff. Oh, they filed this motion. They filed that motion. They don't want cameras in the courtroom. They want publicity banned. 1 month, 2 month, all his entire life is just going by. That's what's really going on here. And the system isn't working. That's just what I wanted to say. Go ahead.
Yeah. I hear you. It's, I think, impossible for any of us to understand how difficult that must be to be in Tyler's shoes and sitting in a cell for that long. It sucks. And,
Can I come out yet?
Anyone's scheduling issues, because then on top of.
Why can't I go out tomorrow? Why can't I go outside tomorrow? Why can't I decide when I want to eat, when I go pee? Why can't I check the internet? Why can't I check X? Why can't I watch a YouTube video? Why can't I touch grass? Why can't I talk to a family member? Why can't I talk to a friend? Why can't I talk to the prison guard? Why can't I sleep on a pillow? Why can't I have a blanket at night?
Mm-hmm.
When we deprive people of their liberty for 9 months, we have to ask why before an evidentiary hearing.
Yeah. I see someone has asked if I'm a mother, and yes, I am a mother to 2 little boys. And trust me, they're actually depicted in that painting right behind me. So, yes, and trust me, I imagine how difficult it would be if one of my sons, God forbid, was, sitting in jail. And I also have spoken on streams in the past about if one of my sons was, to be taken from this world. In both cases, I, as a mother, as a parent, as a human being, could not sit quietly. So I really struggle with the idea that we have not heard from either of those mothers.
Mm-hmm. Something's not right.
Something ain't right. And that's,
at the same time,
one of the many reasons.
At the same time, Charlie never, assuming he's dead, Charlie never gets to hug his kids anymore. He never gets to hug his wife anymore. He never gets to have with his wife anymore. He never gets to do anything anymore. He doesn't get to wake up anymore. He doesn't get to look at the sun anymore. He doesn't get to do anything anymore. He was supposed to do this. He was supposed to do that. Maybe he was going to run for president. None of that can happen anymore. If you go with the official narrative, he's actually dead. He was actually assassinated. So that's the flip side of it. It's not just Tyler Robinson.
Yep, both sides have to be considered in that. But I struggle with the idea that the parents on either side have not spoken up publicly after 9 months.
But like when we get into like X Spaces and we get into YouTube live streams and we get like super deep into like the CO2 pendant gun theory, the palm gun theory, all these different theories, it's all fun and games, but there's real stuff going on too.
Mm-hmm.
Would you like to continue with your perplexity stuff?
Yes, almost done here. So capital preparation. Utah's death penalty is on the table. So that triggers a whole additional layer of mitigation investigation, and even the American Bar Association, those guidelines more than recommend, but strongly recommend the courts follow. They require more time. You shouldn't rush into a death penalty case, even though, the prosecution was quick to call for the death penalty. They don't want you to move into the preliminary hearing stage too early. Co-witnesses and co-defendant coordination. Even in a single defendant case, when your key witnesses include roommates, family members, law enforcement, across multiple agencies, and, requiring scheduling issues with the court and a whole lot of lawyers, scheduling alone can take months. And then finally, defense requested continuances for a good cause. So Kathy Nestor, she filed not only for the July date, she wanted it to be even further out. And so perhaps that's not a stall. It's a lawyer telling the judge, if you make me go, sooner than that, I can't do my job properly.
Mm-hmm. And you're setting up for appeal.
Yep, which so many of the things that have been filed, it appears that they are putting those on the record in the event of an appeal.
Was that the end of that, or is there more?
Take it away. Take it away.
Okay, we're going to move on to. Thank you for that. That was great, Kelly. That's terrific. We're going to move on to the. I want to get this right. This is the affidavit of probable cause that was filed on September 12th, 2025. So 2 days after the incident. This is the very first document that was published in support of the idea that Tyler Robinson did something wrong. This is the words of Officer Brian Davis with the Attorney General. I guess the booking agency was Utah County Sheriff's Office. Do we know who Brian Davis is? I feel like we do. That's one of the cops, right? Oh, I don't have this on screen. Do we remember who Brian Davis is?
That he might. I think maybe an investigator with the Attorney General's office.
That sounds right. Okay, so this is the words of the investigator or the detective, I guess. Or we'll find out. I want to say this was the police officer, but I might be wrong.
I'm like, I don't think that. Yeah, that wasn't someone with UVU. I don't think.
No.
But anyway, we'll go through it.
Okay, I believe there is probable. This is the words of the person writing this document. I believe there is probable cause to charge the defendant with these charges because, well, what are the charges? Aggravated murder, felony discharge of firearm causing serious bodily injury, obstruction of justice, capital first-degree felony conduct. Can get into those later. I'm going to skip through here to try to find the stuff that we don't already know. It talks about who Charlie Kirk was, and he was wearing a white t-shirt, dark pants, sitting under a white canopy. We already know that. He was surrounded by a lot of people around all of the sides. Behind the canopy was a walkway. He was holding a microphone speaking to a crowd. At approximately 12:23 hours, a loud gunshot was heard, and Charlie Kirk appeared to have been hit in the neck. Blood was seen coming out. He was transported to Timpanogos and was pronounced deceased at the hospital. Investigators reviewed the security cameras. They observed an individual on the rooftop of Losey at the time of the shooting. That person will be referred to as suspect. Based on the surveillance camera, this person appears to be a white male with dark-colored hair, with certain observations there, and an American flag. So he's just describing the individual there. Prior to the shooting, suspect appears to walk with a stiff right leg. Suspect's ability to bend his right leg appears to be restricted. So building the case that he had the firearm on his person. At approximately 11:50 hours, a surveillance camera captured suspect walking across a grassy area north of the campus drive. That's the one where the security camera appears to be panning and tilting.
Could you highlight when you're reading so it makes it a little easier, just because it's small for the audience to follow along?
I'm paraphrasing so much that it would slow me down a lot.
Maybe if your mouse is on the side in the white part, then maybe they can see it a little better. We're in the area that you're at generally.
Should I make my mouse bigger?
If it's not too much of a hassle.
Do we have some comments in the meantime?
I was actually searching for a document. I had to zoom my screen out really big to see.
I should almost be done. Where is it? Accessibility. Pointer control. Nope, it's not there. Let's try to find the accessibility stuff. Display. Display contrast. Text size. Pointer size. Here we go. I will make an extra large pointer. And now we can proceed. Is this big enough, Kelly?
Yes. Thank you for my old eyes.
All right. You're not old. Never say that. All right. At approximately 11:50 hours, a UVU surveillance camera first captured suspect walking across a grassy area north of Campus Drive at approximately 800 West. Campus Drive, I remember walking Campus Drive. That's the back road there. Suspect walked south. This is boring. Let's proceed here. Let's try to find. So basically, I'm not going to say that. I wanted to do a mock PC hearing. and like have like people playing different roles, but we decided not to. But I'm gonna like kind of halfway do that here. If I'm the judge and I'm looking at this, what have we seen so far? According to this statement, Charlie Kirk is dead. We don't agree with that, but according to this statement, Charlie Kirk is dead. Okay. And there's a suspect on a roof who appears to have a gun. We don't have a clear way of determining who that suspect is yet. So, and we also don't have visual evidence of the gun. We have someone limping. So that seems a little bit sketch, like just because he's limping, like it's probable cause to believe that he has a firearm, I suppose, maybe. But we need to establish a connection between suspect and Tyler Robinson. So I think that's what we're going to get into now. We have all the stuff of like the TMZ footage here that I'll skip. The area to the north of Campus Drive Road where suspect crossed over consists of a grassy area with the trees on the edge of UVU campus. Investigators discovered a bolt-action rifle wrapped in a dark colored towel. The rifle was determined to be a Mauser Model 98 30-06 caliber bolt-action rifle. The rifle had a scope mounted on top of it. Investigators noted inscriptions that had been engraved on casings found with the rifle. Inscriptions on a fired casing read, I'm not going to read those out. I've heard those on the news way too many times. I'm not going to read those. But they have the inscriptions, the whatever inscriptions, the like social media memes or whatever. Okay. Investigators also discovered a shoe impression on the northeast corner rooftop edge. Okay. All right. Now we get to the part where we talk about Tyler Robinson. I wish they had a paragraph break here, but I suppose not. On the evening of September 11th, the next day, 2025, a family member of Tyler Robinson, just a random nobody, reached out to a family friend who contacted the Washington. Okay, let's fill in some blanks here, shall we? Between this stuff that we just talked about, all the evidence they collected, and Tyler Robinson showing up, what was posted on social media about trying to find evidence and get someone arrested? What's going on right now?
That they're seeking, you mean that they're seeking the public's help? Sorry, there's a delay and it's hard to hear you.
There's $1 million on the table for anyone coming forward with a suspect.
Allegedly.
Yeah. So there is tremendous incentive for someone to bring forward a patsy. So we'll continue. On the evening of September 11th, a family member of Tyler Robinson, some random hillbilly nobody, reached out to a family friend who contacted Washington County Sheriff's Office with information that some random nobody had confessed to them or implied that he had committed the incident. Okay, so someone is just saying that this person did something. Okay. The information was relayed to the Utah County Sheriff's Office and scene investigators at UVU. The information was also conveyed to the FBI. Okay, like so far it's just some random nobody who someone wants $1 million. So whatever, like how do we find out if this is actually true? Investigators reviewed additional video footage and identified, hold up. How did they identify Robinson arriving on UVU campus in a gray Dodge Challenger? Hold up, I'm confused here. Investigators reviewed additional video footage from UVU surveillance and identified Robinson arriving on UVU campus in a gray Dodge Challenger. Do we know exactly what footage that is? Do we have that footage?
Arriving onto campus? No, I don't believe so.
Like, how clear is that footage? I want to know exactly how clear that footage is. Like, is it actually a clear ID or is it just another fuzzy one that's like, meh? That's what I want to know. Because this is the first time in this affidavit that they're actually identifying Tyler Robinson at the scene, right?
Mm-hmm.
So in this video, Tyler Robinson allegedly is observed on video in a plain maroon t-shirt, light colored shorts, black hat, light colored shoes. When encountered in person by investigators in Washington County on September 12th, early morning hours, Robinson was observed in consistent clothing with the surveillance images. That's never made sense to me. Why would he be wearing the exact same clothing?
When he came back?
Yeah, when he came to the Washington County Sheriff's Office. Why is he wearing the same clothes?
I mean, and look, is that, I don't know, is that his favorite color clothes? Like, I mean, I don't know. It
I guess
doesn't make
so.
sense. Yeah, it doesn't make sense. And also then they're going to talk about some clothes that he supposedly tossed out too. So,
And as I'm reading this, it says, okay, let's grant that it is Tyler Robinson in the Dodge Challenger. The person in the gray Dodge Challenger is wearing clothes that are different from suspect. He's not wearing the same clothes as suspect. And apparently the clothes that Tyler Robinson shows up in are not consistent with the clothing of the suspect.
yeah, no, they've discussed that, and in here they're going to talk about some clothes getting tossed out, and if not in this one, then in the indictment.
But up until this point, Robinson is just some random person who happened to be in the area with like thousands of other people. Nothing here suggests that he is actually suspect, except for a family member reached out to a family friend who contacted sheriff saying that Robinson had confessed to them. So what could happen here is somebody knows that Tyler Robinson went to the UVU event and they won $1 million. So they're just going to say that Tyler did it in hopes that they get $1 million. But so far, we have absolutely nothing connecting Tyler Robinson to suspect. Let's proceed. Investigators interviewed a family member of Robinson who stated Robinson had become more political. I don't care. Family member referenced a recent incident in which Robinson came to dinner, mentioned Charlie Kirk was coming to UVU, said that he didn't like him. A lot of people don't like the viewpoints that he had. A lot of people don't. He also said that Robinson stated Kirk was full of hate and spreading hate. A lot of people would believe that. Family member also confirmed Robinson had a gray Dodge Challenger. So far, okay, he doesn't like Charlie Kirk. A lot of people don't. No big deal. He has a Dodge Challenger and he goes to the UVU event. So what? And he doesn't have clothes that match suspect. We don't have PC yet. Would you agree?
Yeah.
Investigators identified an individual as the roommate of Robinson. Investigators interviewed the roommate, this is Lance Twiggs, who stated that his roommate made a joke on Discord. A lot of people make jokes. Investigators asked if he would show them the messages on Discord. He opened it and showed several messages to investigators and allowed investigators to take photos of the screen as each message was shown by Robinson's roommate. These photos consisted of various messages, including content of messages between him and Tyler. What part of this, the content of these messages, stating a need to retrieve a rifle from a drop point, leaving the rifle in a bush, messages related to visually watching the area where a rifle was left, and a message referring to having left the rifle wrapped in a towel. The messages also refer to engraving bullets and a mention of a scope and a rifle being unique. So here, according to these Discord messages, we have, if these Discord messages are actually true, he's just has contact with the rifle. Doesn't mean that he's suspect, just means that he might have dropped off the rifle. This does not establish probable cause for the actual crime, in my opinion. just for having contacted the rifle. And in a PC hearing, you like, yes, you would question the authenticity of the Discord messages, of course. But if you just go by what the paper says, the paper still doesn't get you to probable cause for first-degree murder. Just contact with the rifle. And a lot of people think that that's only what Tyler Robinson did, was he just dropped the rifle off and picked it up. And that's all we've established PC for so far. Based on the evidence detailed in the statement, I believe there's probable cause that Tyler Robinson committed the crimes of aggravated murder. That's the end of the PC affidavit. There's nothing else.
It's pretty weak.
So if I'm the judge, what do we have? We have go ahead.
No. Keep going.
We have suspect who's wearing completely different outfit from Tyler Robinson. We have some random person saying that some random person did it, and that random person is Tyler Robinson. Tyler Robinson, we identify him at the crime scene wearing clothes that are completely different from suspect. He's not limping. He doesn't have the same clothes as suspect, but he's there like a lot of other people. And literally the only other thing linking him to the crime is someone who wants $1 million. And I need to turn these comments off. Someone who wants $1 million saying that he did it, and then some Discord messages saying that he dropped off the rifle. There's no PC for first-degree murder in this document. There's just PC for maybe obstruction of justice. If the messages say that he's actively trying to hide the rifle from the police, you have PC for this. But you have absolutely no PC for felony discharge or aggravated murder.
Yeah.
And that's the reason I played these videos. If it'll pull it up. The reason I played this, not this one. The first one that I played, where it was the video. This is important because, let me just get this off the screen here. And I have a giant mouse still. This is important because you have to focus on what the paper says, because the judge is going to assume that what the paper says is true. But if the paper doesn't say that there's PC, then there's no PC. And what we just saw on that piece of paper is there's no PC.
Do you have the indictment as well?
I do. I'll pull that up. Can you give me a break, though? I'm going to make... I guess I need to keep my mouse big, I guess. I'm going to find the PC affidavit, or not the charging document, right? I'll find that. Let me find that real fast. With my humongous mouse. Tyler Robinson charging document. I have it printed out. I have it printed out, but I want to be able to put it on the screen too.
There you go. Yep.
We fill the dead air.
What? Yes. Oh my gosh. Yeah, I was in the meantime, unfortunately, I had it on my other computer and so I'm limping along, but I wanted to pull up a document from the Aurora Theater shooting. I mean, I have some like behind the scenes, like private documents that had not been shared before. And so anyway, I was working on trying to locate those in my archives, but I had them more accessible on my other computer. I've got like a list of all of these victims like that I spoke to anyway. But the documents filed in this case, those initial documents, the probable cause and the I guess the indictment or whatever they call the charging document there, they're so weak. in comparison to typically the detail that is put into these kinds of documents, in my opinion, in my experience.
Should we pull up the PC affidavit for that one? Aurora shooting.
Wait, no, I don't think we should. I think we should stay on this topic first because the other document has more detail to it. The other document is the one that talks about, you know, the officer running from the, well, it talks about, you know, spotted on video.
I think I just found it. Because that's important. We want to see the context. What should it look like?
That's fine.
That's what you were going to pull up, right?
Well, what I was going to pull up were some other documents, but it's going to take me a little while to find them because they were on my other computer. So I'm trying to go through.
Oh, God.
My files.
Okay, I'm not going to read it, but I want to show the audience what you're talking about.
Yeah.
Okay, what are we noticing here?
Evidence.
Evidence.
When I talk about how different the Aurora Theater shooting was in comparison to this case, you guys, I want you to understand the difference is like night and day. Night and day. And in that case, they still were able to apprehend James Holmes at the scene. There was not a manhunt.
I'm not even halfway done scrolling yet, Kelly. Still scrolling. Almost there. Still not there yet. Still scrolling.
Now you have to look and see what day this was filed on, just so that way we have, you know, a fair amount. Because I mean, they didn't make that. Okay.
Now I'm done.
So now whatever this is much later. So 2023. Huh? What are you looking? Are you?
I don't know.
Craig Tolliver, I don't know what you're on, dude.
Aurora Police Department.
Yeah, but that's not it's just, this should be for James Holmes Aurora Theater shooting. And that was 7/20 of 2012. July 20th, 2012.
This is an affidavit of probable cause for arrest.
Okay, well, that's fine. So not the theater shooting, but something else. Go with it.
That nobody has ever heard of. And that's the level of detail they give it. Well, I don't want to say that nobody has ever heard of. I'm sure this is a very important case to many people.
Okay, so here, wait. So something that had happened on March, 15th or something, 2023. Okay, and then if you look all the way down to the bottom as to when it was filed, I mean, again, I'm pretty sure that said March 2023 at the very bottom as to when it was actually, when the case was actually filed. Very, very bottom. Yep.
March
So
18th.
five days later, right?
Yep.
That massive amount of evidence and.
See what I'm talking about? Do you see what I'm talking about? At the beginning of this stream, I asked, why can't the prosecution figure this shit out?
Language.
Figure this stuff out in 7 days, and then they hand it over. I only did it once.
Oh, I see. I can't even hear any of that stuff.
Oh. Why can't the prosecution get their stuff together in 7 days, like these people did, and then give it to the defense for 7 days? They can form their counter argument, and then we have the PC hearing at day 14. Can we please do that? It's possible. Thank you for providing this context, Kelly, even if I got the wrong document.
That's okay. Yeah. I mean, it's helpful. I just wanted to make sure that I wasn't going on and on about a case that we were looking at a different one. So as long as we were clear on the case and have an example of, okay, this is like the date of the incident, this is the date of the filing, and you can see how typically something should be detailed with evidence to substantiate probable cause, then I think that that's helpful.
Now let's see a counterexample for how this is not done. All right. This is the correct document this time. Tyler James Robinson. What is this document called? This is called this is the charging document. I'm sure there's a more official name for it, but this is like the charging document. Okay. Count 1, aggravated murder. This is all just stuff. First of all, let's scroll to the top. I'm going to start scrolling for listeners now. Still scrolling. And I'm done. That's how long it takes to scroll through this entire document. All right. And most of it is just like literally most, like, okay, let's go down to the part where it actually starts talking about the case. That's about here. This is when it starts talking about the actual case. Start now.
And a good chunk of that was the text messages that they couldn't even provide actual screenshots of that they had to type out or whatever.
Exactly.
Yeah.
So let's read these
They're
counts
liberal with the spacing.
fast. Count 1, aggravated murder, victim targeting enhancement, violent offense committed in the presence of a child. I want to find out if there's a mens rea requirement for in the presence of a child. Do you know what I mean by that?
Could you say that again? It's hard to hear you. I apologize.
Can you look up that law?
A violent offense committed in the presence of a child?
Yeah. I want to know if intent is required.
Okay.
Because like some of these, like there's the actus rea and then the mens rea. You have to know that you're doing it in the presence of a child. But Tyler Robinson or whoever it was didn't necessarily know that. So this charge could easily fall through, I think.
Sure. I mean, they're going to, I think it's kind of expected that they're going to inflate charges anyway that they can like let go of later.
Right. Exactly. But I think it's going to fall through on that merit. Count 2, felony discharge of a firearm, victim targeting enhancement, and then the same thing. Count 3, obstruction of justice, tampering with the witness, violent offense committed in presence of a child, victim targeting enhancement. Okay, probable cause statement reads, and I'm going to paraphrase again because it's actually not long, but it's kind of long. On September 10th, Charlie Kirk was shot and killed. Police found the suspected murder weapon, a bolt-action .30-06 rifle. Over the next 33 hours, police conducted a manhunt. On the evening of September 11th, when Tyler Robinson surrendered, they conducted a manhunt, and then Tyler Robinson surrendered to police at Washington County Sheriff's Office. DNA consistent with Robinson was found on the rifle's trigger. After shooting Mr. Kirk, Robinson hid the gun, discarded the clothing, and told his lover to delete incriminating text messages and not to talk to police. Children were present at the time of the shooting. Then it talks about the shooting that's not actually PC. And then UVU surveillance investigation. The UVU police officer was watching the crowd. As soon as he heard the shot, he began to scan the area for threats. He believed that the shot came from sniper positions noted in a roof area approximately 160 yards away from Mr. Kirk. The Lozy Center roof. I'm going to skip to the part where we find out why it would be Tyler Robinson and not someone else. It just talks about the casings. Okay, here's the important part. Washington County investigation. On the evening of September 11th, as law enforcement continued their investigation, Tyler Robinson went to the Washington County Sheriff's Office with his parents and a family friend to turn himself in. I take issue with that. Was that his intent? Is that
I don't think so, but that's not what they're going for here. They're not they're
not going for the facts here.
Yeah.
It says Robinson's mother stated the following to police on September 11th. The day after the shooting, Robinson's mother saw the photo of the shooter in the news and thought the shooter looked like her son. Robinson's mother called her son, said he was at home sick. Robinson's mother expressed concern. Robinson's father agreed.
Oh. You're yawning.
Robinson's mother explained just some stuff that doesn't mean anything. Okay. Robinson's father reported that when his wife showed him the surveillance image, he agreed that it looked like their son. He also believed that the rifle the police suspected the shooter used matched a rifle that was given to his son as a gift. But, we have some stuff saying that rifle might have been a stock image. So that's an issue. As a result, and, that rifle looks like a lot of other rifles. But in the PC affidavit, all we have is Tyler Robinson dropping the weapon there. We don't have him firing the weapon yet. So Robinson did not respond to some text messages about this. Robinson implied that he planned to take his own life. Doesn't mean anything. Robinson's parents were able to convince him to meet at their home. Doesn't mean anything. As they discussed the situation, Robinson implied he was the shooter and stated that he couldn't go to jail. He implied that he was the shooter. Okay. We need to know what he actually said, though. I don't think that.
Yeah, I mean that was one of the biggest red flags to me. He implied he was the shooter. What?
Yeah,
that's a massive leap to make, but it's important just to remember there that he did not confess. Someone believed that it was implied.
And was it the police officer who thought it was implied, or was it the mother who thought it was implied?
Minimal details.
As they discussed, and the other thing is, did he imply that he was involved, or did he imply that he was the actual shooter? We don't know.
All right.
When asked why he did it, Robinson explained there's too much evil and Charlie Kirk spreads too much hate. They talked about Robinson turning himself in and convinced Robinson to speak with a family friend. And they go on to come in. Police interviewed Robinson's roommate, who says some stuff that is unverifiable. The roommate, I don't really care. And then there's a note. Then we get into the text messages. Police executed a search warrant on Robinson's residence. During that search, police discovered a shell casing. Okay, and then it just goes into the counts again. So basically, all this does is establish proximity. And then, the only actual confession is these text messages. Right?
I mean, that's the closest thing I would say to a confession. And even then, it's not screenshots. We have no context of timing. These could take place over, a day and a half. Like, we don't know.
And is he confessing to participating with other people, or is he confessing to doing the whole thing alone? And like, let's look at exactly where did these text messages come from? Exactly where did they come from? The roommate looked under the keyboard and found a note that stated, I had the opportunity to take out Charlie Kirk and I'm going to take it. Police found a photograph of this note. We need to do handwriting analysis on that. Like, who actually wrote that? Anybody could have. Yes, this is true. We're night owls. Literally anybody could have written that note until we do like a handwriting analysis. I don't buy that. I don't think that's PC of anything. The following text exchange then took place. Like, okay, if I'm the judge, I'm trying to find out, like, oh, sure, there was involvement, but to what extent? To what extent was Tyler Robinson's involvement? Did he just drop off the rifle? Was he participating in a larger scheme? Nothing. Like, the only thing I don't even necessarily see a confession here other than he implied he was the shooter. He implied he was the shooter is the only thing that I see that speaks directly to the aggravated murder charge. Even if we take everything at face value, the only thing is he implied he was the shooter. And I guess, how long have you been planning this? Like, this part kind of speaks to maybe he's working alone. So maybe that part. But like, literally, okay, his DNA is on the trigger. That only gets you to involvement, but we don't know what level of involvement.
Mm-hmm.
So if I'm the judge, I'm asking, like, do we have... I don't know. There's definitely PC here for a lot of the charges, for sure. I just don't know if there's PC for, the victim targeting, maybe in presence of a child. I don't know if there's a mens rea requirement for that. Maybe if you get into some chats, I can find out. Felony discharge, like, this is the one that I take the biggest issue with. Felony discharge of a firearm, and then the murder, aggravated murder.
Right, you're scrolling around fast. Can you go back to the one with the child?
I'll look that up. I know what I'm looking for. I'll look that up once you
Okay.
start getting into some chats.
Okay.
So I don't have, like, I would find PC for most of these charges. I just take issue with felony discharge of a firearm and aggravated murder.
Mm-hmm.
That's where I would stand on this, because I don't know that there's enough to get you to those specific charges.
But I mean, again, they can still. I don't know that the judge at this point would take some of those initial charges or counts, off the table. Just given the entire, the totality of the situation. But maybe.
I mean, you look at Judge Fleischer, he's pretty specific.
He's
Maybe
not handling a murder case, though.
That's true. But maybe we'll be
he's talking
pleasantly
about
surprised.
somebody with weed in the car or something. I couldn't hear it, but so, I mean,
maybe he's a good judge.
I was like, we're not just talking apples and oranges. It's like apples and steak, okay?
It's still PC, though. It's still the same justice system. So maybe he'll actually look at each count and see, is there PC for this count? Is there PC for that count? I don't necessarily... There might be PC for the discharge and for the aggravated murder, but I think that should be scrutinized more than the others. That's what I'll say.
Apples and weed. Thank you.
All right.
Thank you, Jack.
We're past 2 hours now, so let's get into. I know we did have a super chat come in, quite large one, or actually two. Did we do this one?
No, but I messaged to him in the chat from Bronson. Rage Bronson with the $4.99 super chat, just stopping by to throw some support to some of my favorite conspiratards. All love, no hate. I wrote him back and I said something, thank you so much, love, your favorite critical thinkers.
In presence of a minor Utah state statute.
And
I'm gonna start looking this thing up now.
okay. And then, oh man, Roger Lane, thank you so much for that $50 super chat. Thank you both for all of your time, effort, and entertainment. Never a dull moment with us, you know? Never a dull moment.
Which is
Thank
that
you.
to try and? Oh, I don't think I turned super. I don't think we turned. No, we did turn super chats on try and prove it. I wonder which one that went to though.
Awesome. Well, thank you so much, Roger. Really appreciate it.
It probably went to you. It normally goes to you.
I don't know about all that. Let's see here.
I don't know.
Oh, from Gary, Gary Ha 2650, I can't shed this. An ex post saying, I can't explain what's on Frank's phone. Brief video seems to show Charlie's hair near his crown move early, maybe first. Jordan will probably want to address that in a little bit.
Yeah, give me a second, please.
Okay. Yep. There's another one from Chewbacca. I see that Jordan's going to want to address. Okay, here's the funny joke. Thank you, Freshmaker22. Why'd the judge wear a bow tie to the FBI's rigged hearing? Because you knew the patsy wasn't getting a straight tie roll anyway. Trial, tie roll, get it? Didn't. It was funny.
Ah, ha ha.
Didn't. Another one. Oh man, Freshmaker22, you were on a roll. Why'd the FBI leave a key witness on a recording instead of bringing him to court? Because he wasn't here to say anything else?
Because they don't want him to be cross-examined.
Yeah.
Because they know that if Kelly cross-examined him, it would be all over.
Mm-hmm. It's probably why he won't answer his door.
Now, okay,
Ooh.
Now you're saying that out in public. You want to get into that now?
Only to our 500 friends who are in here right now. There's more to come, but...
Yeah, Kelly's been doing some real reporting that I've known about for quite a while that I've kept secret with her. But she's been doing some real reporting. She's been putting her physical safety on the line, which I'm not very happy about. But she's been doing that. Hopefully, I think with the right safety precautions. I've instructed her to do the proper safety precautions. But anyway, she's doing real reporting. She's way better than all of the other collaborators out there. I have the best collaborator.
Thank you. Thank you. I just like to say, don't just talk about it, be about it. So, yeah. Did you find what you were looking for?
I did.
You want to get into it?
Yeah. There is no mens rea requirement in this law. It's just the actus rea. So like if you commit criminal homicide, intentionally cause or attempt to cause serious bodily injury in the presence of a child, then you've violated this subsection and you're guilty of a Class B misdemeanor. There's no mens rea, there's no intent requirement here, so that charge would almost certainly stand. So we can throw that out the door. My suspicion there is incorrect because of the way the law is written. So that is that question is answered.
Yeah, I mean, one could certainly assume that there would be at least someone in a crowd of 3,000 that was under the age of 18. But
under the age of 14, I think it is.
Oh,
Yeah, 14.
You said 14? Sorry. Okay, so
It
under the
says
age of
in
14.
the presence of a minor, but I guess they define minor differently there, I guess. This is what the things I found says.
Okay. Well, yeah, it definitely seemed like it became a family event. There were strollers there, you know. I wouldn't think really about taking, you know, baby to Charlie Kirk, but hey,
Yeah.
when in Utah.
Chewbacca again, I think. Did you see Heavy Duty Country showed a video of a creator? Oh my god.
I I knew you were gonna love that.
Let's pull it up, shall we?
Why not?
If I can find it.
Hey,
Well,
look,
we
Jordan, you made Heavy Duty Country.
did I?
I
Is it
mean-
actually in there? Hold on, let me see if I can pull that up. I didn't know that happened.
You're on a roll, dude. Like wolves
You
in
haven't-
finance.
Well, we both are. We were both in that. So maybe we're both in this too.
I'm like the anonymous person in all these things.
No. Well,
I like it.
last night though, on Gary, he pronounced your name wrong, but he said your name. And he didn't say my name. He didn't say my name. He didn't even mispronounce my name.
Well, because you haven't been on his show.
I should though, because you've been on, Baze has been on, he knows about Danks, and basically, I'm not going to mention the other person who's been on, but basically our whole friend circle has been on except for me, so I think I should go on too. And he did invite me on, he just caved at the last minute. Or not at the last minute, but he didn't follow through.
And Freshmaker 22, I see you on that comment.
Everyone,
it is
man.
definitely on my mind as well.
I found it.
There you go.
Alrighty, folks, let's start with this. Could never be like,
Oh
oh yeah,
gosh, this girl.
yeah, really good. Oh yeah, look at her. Look at her stare at people and be mean. It's like, dude, you're trying too hard. Alrighty, folks, let's start with this.
Theory that Charlie Kirk was killed by an explosive placed in his wireless mic is growing in popularity. And when you look at the reenactments done online, side by side, you can't help but notice the way that the shirt moves, the way that the necklace moves, and the way the body moves are so similar. And now Tucker Carlson openly saying that he believes that Charlie Kirk was killed because
believe he was most likely murdered for his evolving views on Israel.
Which is interesting when it comes to Kirk's society talk. Hey, is Charlie, is that road to the attend fact Mike structure? And this, as always,
Folks, I will be the first one to say that I did not really buy into the exploding mic thing because it just kind of seemed ridiculous. It seemed like there'd be a lot of moving parts with what seems like a major operation like that. But Candace just outed
I guess he doesn't address me, but that's okay. But no, for the record, for the 500 people watching right now, no. That's not what my video was demonstrating. Up here, going back, This is a short video. This test up here is the CO2 pendant gun theory. It is not the exploding microphone theory. The exploding microphone theory, people will say, let's get into it real fast. I know it's not the topic for the night, but a lot of people are interested in it. You can not go out and buy a shaped charge, correct. But what you can do is you can simulate a shaped charge either in Blender. Oh, hold on. Let's go into Blender here. Open Blender. Oh, I need it on the other screen. And get this one out. Blender. Hi, Blender. Let's see how hard it is. This is my Alva Sorcerer stuff, and it's broken right now. I don't know why. There we go. Oh, it's still I don't know what build this is. This is the wrong build. Anyway, sorry. In Blender, we can go into simulations. If my mouse was smaller, layout. Let's just do this real fast. Where is it? Properties, properties, properties. No, I need to just make this properties. This you can use this to make simulations, right? Particle simulations, modifiers, particles, physics simulations, force field. We can do force field. We can do collisions. We can do cloth simulations. That's really important. We can do dynamic paint. I don't know what that is. Rigid body constraints, rigid bodies. We can do fluid simulations. We can do soft body simulations. We can do all the stuff on the computer. So don't tell me that, oh, we can't get shape charges. I don't care. Do it in Blender. Blender knows how to do something that can simulate a shape charge. So, and okay, you don't know how to work Blender. That's okay. I can help you out there too. Necklace simulation Blender tutorial. Oh my God. There's a
in this Blender tutorial
10-minute, 11-minute video telling you exactly how to do chain simulations. Why is that important? Because that's what we need to do. And he shows you how to do all this stuff. And this is the one that I did to test out exploding microphone theory. And I lost all the files, so I don't have it anymore. But you go through this video, and it tells you how to do a necklace on Charlie Kirk's neck. And then you can just put force fields around it and wind forces to simulate cavitation, to simulate exploding microphone theory, to simulate palm gun theory, to simulate all these different theories. It's not hard. It is a 14-minute video, and it's free software. So I don't want to hear the excuse, oh, we can't test exploding microphone theory. It's too hard. No, do it in the computer.
Get him.
This is the guy in our spaces the other night.
Yeah.
Or was it last night? No, it was 2 nights ago, I think.
I don't know. Days have been blending together.
That's my spiel on exploding microphone theory and why they can't test it.
Okay, what do you think about this one?
What you unintentionally showed is it could have been an armed projectile, not shaped charge in the cross, which I said months ago. See, this is Paul's theory, basically. I don't agree with that, though, because it does not explain the necklace behavior. Yeah, it doesn't explain the necklace behavior. And we only see
wait, hold on.
going...
Whoa, wait. Necklace behavior. Do you mean necklace behavior, or do you mean the... Here, I'll do this side. The piece of the shirt that's coming up.
I mean the necklace behavior.
Okay. I mean, in some videos, it does different things than in other videos, I contend.
The necklace does?
Mm-hmm.
Is that... Wait, what do you mean by that?
Well, I just think that in some videos, you can see something if it's the necklace. You know, in other videos, you don't see anything. In some
kinda
videos,
thin,
it
though.
looks like this long. In some
Mhm.
videos, it looks like this, you know?
Yeah. I think there could be reasons for that. But I don't think that it's an armed projectile from the pendant. Number one, necklace behavior, like it doesn't really explain why it would come out like this, basically. At least according to the video footage. And we can have separate opinions on the legitimacy and the chain of custody. But the evidence I see does not point me in that direction because of that. And also, like who sits down one day and decides, okay, we're trying to kill Charlie Kirk. I probably shouldn't say that on YouTube. We're trying to do this to Charlie Kirk. We don't want him to be alive tomorrow. And the weapon we're going to choose is, I don't have it in front of me, but it's a cross pendant. Why is that the weapon that we choose? I don't think that it is. I think you choose the sniper on the roof.
Did you listen at all to that space this evening?
Which one?
Oh,
No, I
that's the
didn't.
one with, oh man. Whoa, that guy. I thought it was an AI bot at first when I joined the space and listened to it for like 30 minutes. Anyway, he would get served on Try and Prove It.
What happened?
I mean, he was, I felt like pretty obnoxious about only sticking to this like small aspect of the debate topic. It was still all related to Charlie Kirk. He was just, apparently he works for Turning Point. Now I don't know a lot about him. I've never heard him debate before. But yeah, they'd like hired him to come in and I don't know, teach people. If I'm thinking of, I assume this is what they're all talking about. But yeah, come in and help train folks that are going to be doing the pick up the mic or whatever tour. So yeah.
And it
I
doesn't
mean,
sound like he's very good at it, so you probably shouldn't be training them then, huh?
oh man, and he's so busy. Said he couldn't manage to do, you know, any more conversation until like next week, you know, because he needed to prepare for his own obligation, whatever.
Because
Anyway,
he's so elite, right?
very elite. Very elite. I could not understand how this could possibly be like legally a conspiracy, which legally only requires 2 or more people to plan to commit a crime. Right.
But when people say conspiracy, typically they mean the government is in on it. They don't mean that 2 people are in on it.
No. God, people get charged with conspiracy all the time. Drug dealers get charged with conspiracy. You know, there's conspiracy and murders, conspiracy. I mean, that's when, probably especially the federal government charges people with conspiracy more often, probably than they end up charging them with, I don't know for a fact.
The
I'm
real
just kind of
crime.
spitballing, but yeah, the real crime, because if it's at least they can get to the point of conspiracy versus being able to have the full meal deal evidence to show that they did the whole thing.
Maybe I missed the context. I don't know what was going on.
It was that Uncle Tom guy that was
Uncle Tom.
Yeah, that was holding the space.
Oh, you told me about in a voice message something. Maybe that should be off air. I don't know.
Okay, probably. If I told you in a voice message, probably.
We did this one, right? I think we did.
Yes. We sure did.
Why did the FBI present? This is really useful. Shout out to StreamYard for figuring out that if you like change the color of a comment slightly to let you know that you already put it on the screen, that's really helpful. Nice job, guys. Just those little tweaks that just make it so much better. Why did the FBI present their key witness on an old audio cassette? Oh, we already did that one, though. Didn't we? Oh, no, we did this one. It's like a duplicate comment. Okay.
It's still a good joke. Sounds better on tape.
Don't you think the pros is the professionals are slow dripping out evidence? In other words, weaponizing the amount of data the defense has? Yes. Yeah. Oh, no, the prosecution. I understand that. Don't you think the prosecution is slow dripping out evidence? In other words, weaponizing the amount of data? Yeah, that's exactly my point at the beginning of this, is they are weaponizing, dragging their feet to, deprive people of liberty for longer, for whatever reason. In my opinion, that's just my opinion. That's not necessarily Kelly's opinion. That's my opinion. Elizabeth says, did anyone get something set up to help Kelly cover costs while in Utah? I think a couple people have, yeah.
I mean, they haven't set anything up yet, but yeah, I got a couple of super chats last week, but I need to share something with you all. That would be amazing.
Oh, like
Thank
a
you for
link.
asking. Yeah. I mean, it's just PayPal. If you want to PayPal me, I would absolutely love that and be honored.
Yeah, she's going to UVU and Utah to cover the trial, or not the trial, the hearing. And we haven't really discussed exactly what I'm going to be doing. I'm going to probably be streaming a lot of it from Try and Prove It. But, if you're in the courthouse the whole time, you're going to be cut off. So I'm going to be alone. That's going to suck.
Mm-hmm.
But I'll probably stream some of it on Try and Prove It. How did you get all that fluid to come out on that video? How did you get all that fluid to come out in that video of Charlie? Maybe they're talking about the field demonstrations?
Or maybe they meant to say, how did they get all that fluid to come out on the video of Charlie? I don't know. But my hypothesis that we're testing is there's a blood pump inside a blood bladder, probably a submersible blood pump, and it just pumps the blood out. Or the videos could be altered and AI, because let's not forget that UVU has a deep fake program that focuses on audio and video and altering it for political discourse.
Mm-hmm.
And I'm actually going to release another cut down of our previous stream tomorrow. One that I had edited a long time ago, and I thought that I'd posted it, but I'd actually posted 2 of the same video. And I just realized it the other day when someone was asking me where they could watch more if they didn't want to watch the entire stream. But I highly recommend, of course, that you watch the whole stream on Try and Prove It.
Of which stream?
Oh, the one where I talked about the AI video. Is the footage fake?
Kelly Barron's latest photo on X is another McClintock creation. Oh, the one where it looks, some people think that there's a patch on his chest. I don't think so. I think it's just fingers. I asked Barron, where was the photographer positioned when that was taken? And then Barron banned you. Well, that's unfortunate.
Well, if anyone has listened to the drama, has listened to the audio of the space from that ordeal, then you probably know how I felt about that. Not just the conversation that occurred, but how I feel about that whole situation.
Wait, what space?
From, God, was that over the weekend? Yeah, with Charles' phone call, and you remember, right?
Yeah, I just didn't know that that was related to this.
It is, because I talked about being sus of the photographer, and
Oh, because how did he get into that position so fast?
mm-hmm.
Yeah, but that's like other drama that we don't discuss on this channel.
Well, it's not
People.
drama. It's not drama in the way that I'm suspicious of the photographer.
That's
But
not drama, but the other part is drama about
that's
people
why
not having.
That's why I was trying to limit what I was saying and be brief. But yeah, I've been
Professional
on record multiple times. I've been on record multiple times in a variety of live streams for a long time saying how I feel. Hopefully, I will get the opportunity to speak to him in person when I am there next week.
Yeah, we have professional ethics here. We don't just go based on like the law. Like, okay, I'm not going to get into specifics, but if we go into the law, like, oh, the law says you can't do this, but it doesn't say you can't do that. So can we just do that? No, because we hold ourselves to a standard higher than the law. Is it illegal to be an asshole? No. Should you be an asshole? No. Just because you're not going to get put in jail for it doesn't mean you should do it.
That's right.
I'll leave it at that. We are at 2 hours 44 minutes now.
Well, I think it's about time to wind down. I see GCL said if I see Erica to check for a tail. You got it. Oh, you guys will hear it here first. Let's see if I can grab my phone so I can read to you exactly. I don't know where my phone is.
Your phone's on the tripod.
Oh, that's why I don't have it. Oh my gosh. That's how you know also it's getting very late. Okay. Hold on, let me pull up my thank you, because I was like, where in the world is my phone? Okay. As y'all know, as you might know, I was trying to get into the hearing. Haven't fully ruled it out yet. However, disappointing news this evening from the courthouse, because they said that there has been a little bit of a change of plan. Let's see, she's handing out wristbands, but okay, they're literally reserving the media slots in the jury box for local and national media. But I've begged.
We're national media.
Well, I agree, but we probably need the try and prove it audience to, I don't even know the right word, but exponentially increase.
We're a global organization because we have a global audience.
Trust me, I've been trying to pitch my case, okay? But I've asked to please be included for if anyone steps out, and that I can at least be in their spot for even a short period of time. I'm like, I'll take the scraps. So, but between that, they now, you guys, only have 14 seats available for the public.
What?
Yeah. I know. 14. I guess I'm gonna guess that Erica and her crew, it was 30. It was 30. And I don't know why they are not creating an overflow room or something like that. Or I don't know. There's got to be a better way to do it.
Yeah. Or get a larger courtroom for like one of the biggest cases that anyone has seen in a very long time.
Absolutely. So
But,
anyway, that's where
I
I'm
mean,
at. But we're gonna. Hey, you know what? Maybe I need to just ask everybody. Like, I don't know. I was like, well, I wonder if I like got a bunch of endorsements from the audience. If I like, could try to twist their arm a little bit, at least to get in there for some period of time. But we'll see. I mean, just everybody say a little prayer for me, put a positive thought, a bunch of positive thoughts out there. Let's just manifest success.
have you done this before? Gone to a... We can talk about that later.
Since I've been in non-traditional media, new media, no, I have not. But
we
back
don't
in
want
my
to
formal days.
we don't want to give competition your secrets on how to
Exactly.
get in.
I know I hesitated to even share that news, but I just want you guys to know that I've been on it behind the scenes, trying to do what I can. And yeah, I'm just going to keep on pushing.
Do you know this Tate Conrad or?
Not off the top of my head, but I'll check that out.
I'm not seeing anything else super pressing. Oh, we have another super chat from Gaz. Thank you.
Thank you.
What is this? I don't think we need to talk to Elizabeth Lane. She has quite the potty mouth. She's also going off. Yeah, I don't really care. I don't think Kelly does either.
I mean, it'd be nice, of course, but oh, thank you. I think it's Kelly Raybon, just KELIRABON. I can't double check on my phone right now, but I'm pretty, because it's what we're using for this stream.
Let me see if I can. They have a super complicated. I don't know. It's not letting me search.
Oh, it's not. It makes you look from a phone, I think. But I'm pretty sure that it's Kelly Raybon, KELIRABON.
All right, that's gonna. I'm sometimes, but not like her.
Not like that. Yeah, she says
You have
nasty words.
no idea.
Oh my gosh.
And not just once, over and over again. That'll do it for any final thoughts, Kelly?
That was a mic drop moment. Snake Baby says, I'm way worse. So I don't know.
All right. That'll do it for tonight's show. Thank everyone for joining us.
Thanks for your patience working through the tech issues, folks.
The Candace Sean Ryan came out. I don't know if we want to. Maybe
it's
if the
too
computer
hard at this point. Maybe we can do that.
Maybe if the computer coming in the mail comes tomorrow.
Yeah.
Maybe we'll stream a reaction to that.
And we made a proactive decision that evening to not stream it. We just want you guys to know that we felt that it was not ethical or maybe not legal, to stream it because it was behind a paywall. And if you just think
hold on. Not everyone knows the context here. The context is Candace Owens. We did a reaction stream to Candace Owens last week or something. Had some certain comments, whatever. We got a lot of views, and then Candace Owens went on Sean Ryan, but it came out first under Patreon behind a paywall, and this is what Kelly's talking about.
Yep. And so because it was behind a paywall, even though, $5, if there would be a few hundred people, a few thousand people, whatever, watching our stream. I mean, that's just not right, because that's the purpose of the paywall, is for another creator to make their content exclusive. And that we just felt like that would be not right. It would be undercutting someone.
I
Even
think,
though,
there's a few channels out there who don't have the same ethical standards that we do, and they decided to stream it when it was still behind a paywall. And I think that there's a YouTube god behind a door somewhere who's cackling in laughter, and they're about to come out from behind that door and lay down the hammer on all the channels who done it. And something bad's about to happen to all those people, I think. Because it's like, yeah, that's clearly blatantly unethical, and some people chose to do it anyway.
I'd be pissed.
Yeah. That'll do it for tonight's show. Thank you, everyone, for coming on. We appreciate coming on. Thank you.
Thank you. We'll see you next time.